Hello everyone, this is day 48 of Polity Daily Drill. Let's begin. First question. Consider the following statements regarding national emergency. Article 358 stipulates that the suspension of fundamental rights under Article 19 requires a distinct presidential order. Number 2, Article 359 automatically suspends the right to approach any court for the enforcement of fundamental rights except for the violation of Article 20 and 21. Now, see, both statements are partially correct, but they have been interchanged. So, Article 358, yes, it stipulates the suspension of Article 19, but there is no need for any distinct presidential order. The moment a national emergency is imposed, is proclaimed on external reasons, that is on the ground of war or external aggression, your fundamental right of Article 19 is suspended. Now, when it comes to national emergencies imposition on any ground, be it war, be it external aggression, or even armed rebellion, your right to move to the court for the enforcement of all other fundamental rights, that can also be suspended. Right is not being suspended. Your right to move to court is being suspended. But this requires, it's not automatic, this requires a presidential order. So Article 358 is what is automatic. 359 says you need a presidential order. So 1 is wrong, 2 is wrong, both are wrong. Right answer is neither 1 nor 2. Now one more thing, when you look at Articles 358 and 359, under Article 358 the right, that is Article 19, is getting suspended. Under Article 359 your fundamental rights are not being suspended. For a temporary period, that is till the emergency is in force, you cannot just claim or enjoy those rights. Okay, and one more thing. Article 358 says that Article 19 is suspended for the entire duration of the emergency and for the entire area where the emergency has been proclaimed. But under Article 359, there can be selective suspension of your right to move to court. So it is possible that for the first 10 days, the right of people to move to court for protection of Article 25 is suspended for the people of, let's say, Kerala, and for the next 10 days it's done for Nagaland, next 20 days it is done for, say, UP. So it can be selective. That's the point to be observed. Okay, moving on to question number 2. What is the primary distinction between the parliamentary systems of India and Britain? So number 1, or A, in India the head of state is directly elected, whereas in Britain the head of state is elected indirectly. So we know very well Britain has a what? Monarchy. When you have a monarchy, which means what? When you have a monarchy, the head of state's position is an inherited one or a hereditary post. You inherit the post. In India, the head of state is elected, but not directly. Who is the head of the state in India? It's the president, and he or she is not elected directly but indirectly. Why? Because we vote. People vote. So A is wrong. B, in India the head of state is a monarch. Of course this is wrong. Head of state is not a monarch. C, in India the head of state is elected, whereas in Britain the head of state inherits the position. Yes, that's correct. Right, now you can see that in India the head of state is elected. Directly or indirectly is not clarified, but yes, the statement per se is correct. So C is the right answer. Let's read D as well. In India the head of the state is appointed by the Prime Minister, while in Britain the head of state is elected. It is also wrong. C is the right answer. Moving on to question number 3. The fundamental duties. Okay, so consider the following statements with respect to or with reference to fundamental duties. They can be used by the courts to determine the constitutional validity of laws. See, the Supreme Court had said back in 1990s only, in the year 1992, that if the court feels that to enforce a duty, a law has been made, then the court can, based on complete discretion of the court, it can also compromise with Article 14 and Article 19 in order to fulfill their duty for the citizens. That is possible. So the court can use fundamental duties also to ensure the constitutional validity of laws. They can be used. Can be used. So one is correct. Number 2, Parliament can provide for a penalty in case of failure in the fulfillment of any fundamental duty. Yes. As of now, there is no penalty. In future, can we have a penalty? Yes, of course. Parliament can provide for a penalty in case we don't fulfill our fundamental duties. 2 is also correct. Which of the statements is or are correct? Both 1 and 2 are correct. C is the right answer. Now question 4. A minister cannot participate in the proceedings of a house of which he is not a member. Okay. A minister who is not a member of either house cannot participate in the proceedings of both the houses. And number 3, the Attorney General of India can take part in the proceedings of both houses of the Parliament. This is nothing but a question based on Article 88. Article 88 says that every minister and the Attorney General can take part in the proceedings of either house, can sit and speak in either house, can take part in the committee meetings of either house, any committee of which they are made a member, of course, but will not get to vote, because your voting in a house flows from membership. So if you are not a member of the house, you cannot vote in that house. So a minister cannot participate in the proceedings is wrong. Minister can participate in the proceedings of either house. And number 2, a minister who is not a member of either house cannot participate in the proceedings. Again, a minister who is not a member of either house will not be allowed to vote anywhere, but he can sit and speak in any house. This is also wrong. Number 3, the Attorney General can take part in the proceedings. Yes, Attorney General can sit and speak in both the houses, though he cannot vote because he or she is not a member of any house. How many statements are correct? So the answer is A, only 1. And the last question for today, with reference to the leader of the house in the Lok Sabha, consider the following statements. It is a constitutional office added via the 42nd Amendment to the Constitution. Number 2, Prime Minister is a leader of Lok Sabha irrespective of his membership. And number 3, as per Lok Sabha rules, the Speaker must transmit information on disqualification of members on ground of defection to the leader of the house. So statement 1 is wrong. Leader of the house, leader of opposition, these are not mentioned in the Constitution. Okay, so they have not been added. These are not constitutional offices. Number 2 is also wrong. Prime Minister is not the leader of Lok Sabha. Prime Minister is the leader of whichever house he or she is a member of. So yes, right now you can say that the PM, or in the previous Lok Sabha, the 17th one, the PM was a leader of Lok Sabha. Why? Because he was an MP in Lok Sabha. But prior to that situation, when Dr. Manmohan Singh was a Prime Minister, he was an MP in the Rajya Sabha, and hence he was a leader of Rajya Sabha. And Narendra Modi was an MP in the Lok Sabha, and hence he was the leader of Lok Sabha. So the Lok Sabha and Rajya Sabha rules say that if PM is a member of that house, he or she becomes the leader of the house, not just Lok Sabha, any house. And 3 is also wrong. There is no such Lok Sabha rule which says that the Speaker has to transmit information to the leader of the house when he disqualifies a member on grounds of defection. There is nothing mentioned anywhere. So how many of the above statements are incorrect? All 3, C, are incorrect. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that's all for me. Jai Hind.